Hi everyone, this is Eric Rodevois. I'm doing a video here in Washington, D.C. in our D.C. office, EPGD Attorneys at Law, 5 Minutes with Eric. And so what I want to talk about today is intellectual property. Okay, so I get calls all the time. It's typically related to business owners. My law firm focuses on business law, business owners. And so the business owner, maybe we've done a contract for them, maybe we've helped them with a non-compete with their clients. They'll call me up and say, hey, I got this cool idea, this cool brand, this cool whatever, I'd like to, and they always, well, they don't always, but they often get the terminology wrong. So let's go over the terminology together. Patents, okay, patent law is where you have an invention. Now, we are not patent lawyers. We refer to the best patent lawyers in the United States. So if you have an invention, I'll make an introduction. I won't make $1 from the introduction. I'll just introduce you to our friends. A patent lawyer must take a special bar exam, and they must be an engineer or a scientist. So it's pretty cool. In fact, they say that patent lawyers have the highest quality of life and satisfaction. They're getting to play with inventions all day long. The second type of intellectual property is copyrights. Okay, copyrights is a vast area, but it's basically content. Whether it's musical content, photographic, artwork, videos, audio, written, it's content. So for many of my clients, they'll have written a book or written the content on their website, or they'll be taking pictures, or they'll be an artist, or whatever it is. And so what we can do is we can register that content, and it's actually pretty inexpensive and pretty fast with the Library of Congress. They make it easy to do because there's so much content in the world. I mean, this video is my content. Copyright EPGD, there you go, 2018. And so you register it, and the reason you register it, just like the reason you register your patent, the reason you register your trademark, the reason you register your copyright, is because then that gives you access to the federal courts. Federal courts are generally better, more efficient, faster, and you can get access to federal statutes. And the federal copyright statute, the federal trademark statute, for example, these award attorney's fees if someone is copying your, in this case, copyright. The third area of intellectual property is trademarks, okay? Trademarks is branding. So a company might own hundreds of brands, and the brands are registered either as a word or as a logo, or both, but it's separate applications and separate filing fees with the government. And they have what's called the Nyse Agreement. Nice is the city in the south of France. It's an international treaty where all the signatory countries, which is most of the civilized world, have agreed to the 45 different categories of goods and services that represent everything that humanity does or sells. It's amazing, like the nerds who sat down and figured out that list. So lawyers, we fall under category 45. Just, that's a fun fact. So what we do is we can take your branding, we can figure out what it is you're actually selling, we can figure out the category, and then we apply. Again, once you get it registered, that's done with the USPTO, the United States Patent and Trademark Office. They handle the patents and the trademarks. Remember, the copyrights are handled with the Library of Congress. Once it's registered, then you can use that little R. Do not use the little R symbol if you don't have a federal registered trademark. It is actually a violation of law to misuse that symbol. And it's a reason that they will use to deny your application if later on you try and apply. The reason you get the registration, you get nationwide. It's automatically presumed that everyone in the world knows about you. And if you have to sue someone, you get federal courts and attorney's fees. These are very powerful. Okay? And the last type of intellectual property, and the one that most people don't even really think about or know about, is secrets. Okay? Now, secrets, like the Coca-Cola formula, they could have patented Coca-Cola, but in order to patent it, you would have had to reveal the formula. So what they did is they just locked it under lock and key. Everyone who works for President Trump has to sign a non-disclosure agreement. That's something he makes all of his employees do. And the reason for that is because it protects the secrets. Most companies have client lists. That could be your most valuable asset, especially in the service industry. Your past client is a very, very valuable thing that took years to build. So where we work with our clients, we are either protecting, or once they're protected, registered, trademarked, copyrighted, maybe contracts for the employees, then we are enforcing. If someone's copying your brand, if someone's copying your content, if someone's copying your invention, if someone's copying your client list, you need a lawyer, you need to take it seriously. And if you wait too long, you might waive your rights. So in a nutshell, that's intellectual property law. Remember, we are not patent lawyers, but the trademarks and copyright and secrets is my favorite area of the law. I love coming to work every day. Thank you so much.